to do exclusively public service broadcasting. And that is what the Finns have done. And the result is fantastic. Despite the IT savvy of Finns, I mean, today, the best social media platform and the most trusted social media platforms in Finland is Yle. And there was a survey conducted about some 5 years ago, and they asked citizens, whom do you trust? Number one was police. Number two was Yle. Police. But number two was Yle. That is the Finnish public service broadcaster. Because it is insulated from advertising business, their institution. That is what we are saying that. And secondly, let me bring you to the other side of this euphoria around IT, artificial intelligence. Please, put on your data and travel across the country and see whether when you move beyond Accra on the road, you'll be getting data. Find out the digital access numbers for Ghana and see who is not on it. And who will it take and the telco networks. And I'm saying this so-called AI and new media is a beautiful conversation by urban dwellers like us. But for GBC, we can assure you that we have large swaths of the country where, when it comes to accessing information, even if you have a smartphone, you are not going to get it. You will have to rely on the public service broadcaster too. And I also tell you this, it will go into radio stations to keep them on, not GTV and not GBC News. That is how we operate. Most of our resources are into keeping our radio stations alive. And they are alive not to do advertising to raise money. They are alive because they make sure that at least what is happening in the capital, in parliament, in the court, at the executive arm of government, we make sure they hear it in their language, and that is critical. How to get them, and that is public service. That's why we keep saying that it's not about the advertising, it's about universality of access and diversity of content. And that is even in a case where everybody has access to social media, you will still need a social media platform that is trustworthy, and that cannot be subjected to the private interest of the owner of the platform. And that is what GBC does, is to cure the tendency for the private-owned media to seek their private interest.
Thank you for fielding those questions. We will open the conversation to all the participants here, so you can take those questions, and then after that we open up the conversation. We have all of you here, but we'll have Mr. Tanko Musa will take his turn answering those questions, and then we'll give it to the audience. Thank you.
Thank you very much, Professor Chair. There was a question from my lady where you asked whether are we trying to suggest that there should not be any form of intervention in the way the media exercises is right. Certainly, that's not the case at all, my lady. What we are suggesting is that, in as much as we recognize that the media, they have a responsibility, if you look at the way those provisions have been actually explored, they have been explored in a way that has been so principles on freedom of expression in Africa. They do give some sort of guideline or framework in terms of if you're going to use the limitation provisions to deal with the media. They said that freedom of expression should not be restricted on public order or national security grounds unless there is a real risk of harm to a legitimate interest, and there is a close link between the risk of harm and then the expressions. If you look at Section 208, when it talks about misleading, when it talks about tendency.
So what is your recommendation on that? So is the argument that the limitation clause in the Constitution, when it comes to restricting rights, that the clause that limits rights is too broadly written, is too narrowly written. We must tighten the kind of debate we have.
Yeah.
You have a right, and then it is restricted.
Yeah.
But the restriction itself is also restricted. In many democracies, the way they understand the restriction is that rights are not absolute, but restrictions are not absolute either. So sometimes the way you couch the restrictions is more important actually than the way you couch the rights, because everybody is looking at the restriction. Should we do something about the restrictions? That's the focus of your argument, that we should take a look at the language of the restrictions and tighten it.
That's our suggestion. Our suggestion is that if you look at the provisions, where those provisions are made, we are suggesting that there should be a preamble where that preamble would provide some framework. So, for instance, some interpretation. And then we are saying that whenever issues about the limitations are coming out, there should be some sort of presumption of openness. There should be issues about proportionality, and there should be some guiding principles, and this can only be done if those provisions are actually clearly defined. But the way they are couched now, it leaves room for abuse, and that is what we are concerned about. Yeah. There was also an issue, and I see my senior here, the NMC issue, and then we have actually, Prof. Chair, you talked about the Supreme Court decision where when the NMC wanted to actually intervene as a result of the public concerns, and then if you like, the backlash that they encountered. And I don't know, but maybe George might talk to it later, where I didn't think the NMC didn't come back to do much about it. But what we are saying is that the powers of the NMC should be looked at, and it should be looked at in a way that gives them much more power. Because as things stand now, when you look at the NMC, when the NMC even invites people before them, people can choose to come or not to come. But we are saying that if we're going to give the NMC some powers to be able to deal with this, we should look at the provision where the NCA is providing, if you like, the license, and then NMC is supposed to be, quote and unquote, the regulator. We're saying that provide the NMC, maybe give the NMC some sort of quasi-judicial power where, I mean, if you are invited before the NMC and you fail or willfully refuse to come before the NMC, then you are taking the risk where maybe it could be a referral to the High Court in terms of the sanctions.
Okay.
But then the issue you raise about what the Supreme Court also said is the sanctions. What language? The language that was introduced in that provision was what actually the Supreme Court was concerned about, because they were worried that they've seen some language that by and large introduces censorship, introduces criminality, and all those things. And my lady was asking the question whether why can't we have civil remedies to deal with these situations? Oh, no, you are saying that, are we suggesting that we should take out the issues about criminal aspects? We're saying that, I mean, we had a conversation among ourselves where we're saying that, why not? Why can't we make provisions for issue provisions? The way things are now, it is not something that actually deals with the situation as we stand. If you look at Section 208 and the Electronic Communications Act, I mean, other jurisdictions, their high court, their superior courts have considered them to be inconsistent with the international conventions of media freedom and independence. But we continue to maintain them in our books. And whenever you raise those issues, the issues that come up would be that, well, freedom is not absolute. It is what? Qualified. And those qualifications are what is needed. You talked about reasonableness. These are vague concepts. If we talk about reasonableness, who is the reasonable person that we are looking at here? Are we talking about the naive person? Are we talking about somebody who is unusually suspicious? And by and large, what we see in our context is that you see that the actors, the political actors, always go to the side of either they will pretend to be naive, it satisfies their interest, or they will be unusually suspicious. And we are saying that let's deal with this lacuna by coming up with a framework where we would have a preamble that interprets the circumstances that could lead to an interference. And even when we have to maintain some of these provisions, there should be some sort of periodic review to see how things are being implemented and all those things. And yes, you are right, because the public is always very critical of the media because there is also the lack of media literacy in our society. And yet, they are also tilted towards the sensationalism. They like the sensationalism, but they don't seem to appreciate the fact that that sensationalism also leads to all sorts of things that they are worried about. So we have, in the extensive submission, we made provisions where maybe we need to consider issues about media literacy. At what stage in our educational curricula are we going to introduce it? Is it about time we introduce that in our educational system where media literacy would be part of our educational architecture? These are all issues that we have talked about. There was an issue about the profits. Which one was that? Media responsibility, then issue, and then we have issues. The issue about economic independence of the media is also an issue, which by and large, the issue of media ownership. We have actually seen a situation where it is very opaque, it is shrouded in secrecy, and because of that, all sorts of people, especially political actors or politically exposed people, are actually getting the license to operate media houses. And as a result of that, because of the abysmal nature of our economic, independence of the media, this situation is abused, and it leads to also, A is a voluntary organization, so you may not ask everybody to be part of GJ, but the ethics, there is a standard code of ethics. And we are thinking that, well, if we are talking about professionalism, and to make sure that the public is actually aligning with us in the way we do things, our code of ethics, we should find a way of linking, if you like, the regulator. When the regulator is issuing you with the license, it should be a way where when you get that license, it should be factored in your media management, where the code of ethics would be taken into account in terms of whether or not your license can be reviewed and all that. But the issue of the NMC came out quite a lot, and we think that the way it is now, its composition, the powers it has to be looked at if we really want to make some headway. I don't know whether at this stage I may want to just open it up for my other colleagues. There was another question.
That is the chairman's job. You want to have the mic, and then you circulate it within your clip. But I think we can open it up. Of course, other members of GJ.
Yeah, Mr. Chairman. No, I'm saying that at this stage we want to come back to you and then maybe open it up for my other colleagues too. Also, yeah.
That's exactly what we want to do. Yeah. Okay, so thank you very much for again adding to the conversation. So the floor is open. 2 presentations, but like I said, you don't have to limit yourself to those 2 presentations. You have your own viewpoint you want to share with us. You are most welcome to do that as well.
Yeah. So, Mr. Chairman, just to add a bit, it's just an addition to what the Media Coalition had been has already presented. Actually, there's a conversation on the table about NMC NCA measure. I think produced, of which some of the observers, EU report specifically, has made some recommendations and has come to the table of the GJ a number of times, asking questions what we think as an institution about merging NCA and the work of the NMC, given the fact that they have been working, which has created some omission in terms of ensuring that there's that oversight and a responsibility towards the issues that are being raised about providing spectrum and not ensuring that these spectrums are providing what they need to, and who are actually owning them, and do they really need to own them, and the issue generally about media regulations that are coming up. I think that we need to consider the issue as we go along. And from our side, we've also talked about the fact that we actually need to have a dialogue on that particular issue, whether or not the NMC or the NTA should work in isolation or should be merged. We understand that one is a constitutional.
What is your position? So
my position, I would wish there should be
GJA's position on.
I will not say that GJ, because we never concluded on it. It's something that, and I believe that everything that we are talking about at this time.
We are going to make recommendations, very concrete ones. So we need help making those recommendations, right? So if you think that the better model is to have a unitary body, that's NCA work and NMC work all one. If you think that's a better model, I doubt that that is a better model, but if you think that that's a better model, then you make the case for it and you tell us why.
The question then will be, what role is NCA playing and what role is NMC playing together? If we need to ensure that at the end of the day, we are expecting the results that we're expecting. In terms of media regulation, which is a problem now, we all agree, given the way the media has metamorphosed over time. So if it's an issue that we need to look at, I would think that we need to look at more critically. But I will not conclude. It's still a suggestion.
We will conclude.
Yeah.
We need conclusion.
And also, just a little point, and then I can give it. I think the issue of one issue that I think is a issue within the media ecosystem and a threat to our democracy is the issue of misinformation, disinformation, and all of that. So as we deliberate, we need to look at how can we cure that issue? How can we cure the issue of misinformation and disinformation? Maybe not ultimately, but manage it. Manage it. We know before now that misinformation, disinformation was not a problem when we had just the state-owned media. So there was an outlet where if you wanted to manage information or get, I would say, a certain kind of information that was tilted to the greater good, that's where you went to. But with the other media coming out, which we cannot eliminate, I mean, we need them as well. It's a free media, 1992 Constitution allows that. But I'm thinking that we need to look at how we can cure the issue of misinformation and disinformation as we are trying to amend some aspects of the Constitution. That's just my take on this. It's something that we have to think. I don't have the ultimate answer, but I think that it's something that we need to look at very critically because we know it's been a threat even to our elections and all of that. Thank you very much.
Thank you. Yes, Brahma.
Start by saying that if there is one area where there has been a lot of shifts since the 1992 Constitution came into being, it would be in the media sector in terms of transformation, growth, as a result of which I think we've gotten ourselves into a kind of a fix where we certainly want to affirm the freedoms that must exist, but we've also come to a point where we need to also look at how those freedoms are being exercised. And I want to reference a position by Justice Afre in 1993 when there was a discussion about private radio broadcast in Ghana and what must be done. And looking at it from the legal point of view, he made a point about the framing of the Constitution and how, if care is not taken, we'll get to a point where media will become tools and avenues for committing fraud. And in fact, I think we are there. Because we are in a situation where we have media houses that are, doing money doubling broadcasts, We have a situation where people are using media for spiritual things, for perpetrating, issues of herbal drugs that will cure every disease and so on and so forth. And we are basically helpless. We have media houses that are essentially saying anything. Can say our military commanders are useless. Otherwise, elsewhere, what is happening in this country, there should have been a coup d'etat, and nothing happens. So we are at that point, platforms and tools for perpetration of fraud. And as I said, we are there. And his point was that perhaps we have a unique situation where we say the media do not require licenses or registration to establish. And I think it is the case as at now. And I think that is what inspired Reku Brobe, for example, to set up Radio I. And that, I don't know whether it has been concluded, whether I can set up a broadcast station now. If I don't need spectrum from NCA, then I can go ahead because I don't need license or I don't need to register. So I think we are at a point where we need to really look at the freedom provisions and generally the provisions within the media. First off, I want to perhaps comment on Professor Amin's points about public service media or GBC as it is.
May I take you to 1623, just the point you made about this license, right? So 1623 says, there shall be no impediment to the establishment of private press or media. Is this provision obsolete? Should we rewrite it?
I think so, because one of the points Justice Afrem makes is, for example, that ideally there should be a provision for, if you want to set up a media, a radio station, for example, a requirement on what is your financial capability? What is the board that you are going to, use for running the radio station? Are these people persons that, we would say, okay, if these people are behind the radio station, we can guarantee that they would comply with at least the basic standards, the basic ethics, and so on and so forth. But today, it isn't like that, and that is what perhaps the opportunity is there for every MP to own a media house, every religious leader to own a media house, and so on. So, Prof, my point was...
But I think it's, can we stay on that point?
Okay.
It's a significant one, right?
Okay.
So, your point is, yes, to enter this market, there should be some pre-entry regulation. Yes. Say you submit your documents, registration documents, your board, your corporate documents to a body. Say the NMC.
Yes.
The NMC vets it, says, yeah, this is an appropriate body to operate, and then the NMC recommends to say the NCA, yes, right? The one that gives you the spectrum, so that we are trying to now figure out a relationship between these two bodies. But so maybe you could develop that idea further. I think it's helpful because if you are saying that there has been such significant transformation in this one sector since 1992, then the Constitution has to evolve to basically, in the direction in which the industry is going. And I think this idea that you must have some pre-registration vetting of your whatever it is, and that if it is done by an independent regulator, then the risk that the government will use it to keep out certain other voices would be minimized. And then that regulator then recommends that, yes, you can grant a license, a spectrum or something.
Yes,
Sule, before you come in, the question of licensing, as stated in 3 here, has a historical justification. Prior to the Fourth Republic, and since the 1960s, or even maybe from the Minister of Information, and this had been used over the years to deny so many people the right to set up newspapers and so on. This is what the framers of the Constitution wanted to avoid. Now, nowadays, if you want to get a frequency to do broadcasting, there are certain things you must satisfy. The problem is not that there are no such prior, what do you call it, requirements. The problem is that because the NCA is directly under the executive, the political parties have bastardized its role, and any regime that comes in dishes out frequencies, and so because of that, there's no regulation there anymore at the national, call it, lecture.
You would retain 1623 or in the present form, in the light of the history, or would you add more protections in there to prevent the first mischief that we try to cure, which is we don't want government or ministers issuing licenses, but we don't also want to go to the other end of the spectrum where it's a free market, it's free for all, there's no, so somewhere in the middle is where we might settle, if that's with more transparency, more
media commission, so on. Now, when the NCA is established with all its, but the process of giving authorization for broadcasting should be the work of the organization or otherwise. Now, the president at the time and the Attorney General, Minister of Justice at the time, told us that, according to the chairman, it would be over his dead body for this to be done by the, what do you call it, by the NMC. And so everything was given to the NCA to do. Later on, over some time, they even allowed now a member of the, I think the executive secretary or a member of the NMC to be a member of the National Media Commission should give authorization, and then the NCA does the technical work of plotting the frequencies and supervising the other technical things and so on, but it has never been done. As to the requirements for whether you qualify to do this or that, it can be done, but it ought to be done in a way that does not also go overboard by introducing certain things that may disqualify certain people from authorization. For instance, if you were to add something like, because we are worried about content standards, if you were to have the editorial staff who have a university degree, people will fight that. I would fight that because I do know that some of the problems we want to cure today are committed by people with university degrees. So that's neither here nor there. The point is, how do you regulate the content? And this is where the problem actually lies. And this is where the question of the NMC's powers are needed. And the NMC's powers should not also be such that they deny people the freedom to do the work. You can have a set of rules that a more professional, how do you call it, regulator, it's been done in South Africa, elsewhere. But also you cannot say that, therefore, the NMC, you see, actually, part of the problem now is that the NMC also has the mandate to get legislation to regulate the media. It has made some attempts, but the courts have also frustrated the National Media Commission. George is here to say. So what we are talking about, it seems to some of us that we need a whole reconfiguration of that whole realm of media regulation and so on. So perhaps
my recommendation would be to say that to be eligible to set up a broadcasting license from the NMC, and the NMC would have done the necessary vetting. Do you have the fundament from the NMC and says, Prof. Kwesi Prempeh is eligible for this? as we speak now, if you want to know the true owners behind perhaps 70% of our radio stations, you wouldn't know. But and then these are the board of directors or the people who are subscribing to it. So we would avoid the situation where people are just going behind some people and setting up radio stations for political party propaganda and all the kinds of things that we are seeing. So if we have a provision that says an application shall be made to the National Media Commission, and based on eligible blah blah blah, the Media Commission shall provide, or I think, sorry, the NCA, I think will be curing something. I wouldn't say a merger between NMC and NCA. That's impossible because there are certain technical things that the NCA handles. I mean, data, the spectrum, the frequencies, the aeronautics should be doing. I think the biggest problem we have in the media ecosystem now is the fact that there's a regulator in text and no regulator in practice. That's what it is. The LI that Prof references, LI 2224, which was, I think in 2014, submit some sort of programming to the NMC for vetting so that if you breach certain requirements, you could be held accountable. Issued a statement challenging some of the things before Giba went to the Supreme Court. But you need to also read the Supreme Court ruling, where it did not just say the NMC knows what to do. If it wants this thing to work, it's not about completely abandoning it as dealt with. And I think that the NMC possibly should revisit LI 2224. And I would also recommend that members of the commission should also look at that. The other thing that I want to bring forward is, in all this, we want to see a stronger media ecosystem. A media ecosystem that is able to hold duty bearers accountable as provided for by the Constitution, where it says all these freedoms are granted not just for the sake of freedoms, but so that the media are able to hold the government of the day accountable to the people of our country. So we need a very critical media, strong media, and all of that. But what is emerging is a phenomenon of a lot of, because they have the resources, either to stifle you, to prevent you from going on, or to maybe show you where power lies. We ran the Fourth Estate, and we are dealing with a number of these cases where, quite clearly, in one instance, then you are taken to court for defamation because you are said to have destroyed somebody's business in one way or the other. So we are seeing a lot of slap suits, as they call it, and I'm wondering whether in some way we can make a provision that journalists will have the liberty to challenge certain cases on the basis of they being slaps, so that there could even be early determination of the cases, just as maybe people do no case, there's a case to answer, and so on and so forth, so that if it is determined to be a slap suit, it is ended as early as practicable to allow journalists who want to do critical work to continue their work. There's one thing that owned company for signal distribution, and I think it was a very, very dangerous thing that was being done, in line with this, our digital migration processes. The executive arm essentially established a company. George, I've forgotten the name. Is it Signal Distribution Company Limited or whatever it is called? And this company was going to be responsible for the distribution of television signals, all television signals, including GBC signals, said that if you broadcast some content that the company says we can't distribute, it means you've just broadcast, but it won't go anywhere. We don't like it. Basically, your content is not distributed, and it stays there. And I think it's an existing company. We need to look at that. Our argument was that in Kenya, in Tanzania, and elsewhere, that function has been given to the state broadcaster as part of the mechanisms to even raise funding, because they don't distribute your content for free. And the state is doing that, and therefore the NMC has oversight over it, so that you cannot arbitrarily, as government, decide which station's content to distribute and which one not to distribute. So it's something that I think we should avert our minds to. George may even bring it up better, but if we allow it to stay, I think that it's a way to bypass the ombudsman role of NMC. And finally, but not in the way we have had it all the way till now. Because, for example, talking about local language broadcast, or Kusal as a local language being spoken on radio, the only way to get that was Ura radio in Bolga. If I were to do that, to listen to Dagare in Upper West, it would have been Radio Upper West. In Volta region, to listen to Ever, it would have been maybe the GBC station there. But today, I can have Kusal being spoken on Quality FM in Garu, Zebs FM in Zebila, Max FM in Binduri. You come to Bolga, A1 radio is doing Guruni. You go to Upper West, Radio Radford FM is doing Sisale, Freed FM is doing Dagare. And if you go to these communities, the stations they will tell you they listen to as their source of information. It's not the GBC station. It is these local FM stations. So do we need GBC in the way it is, with FM stations all over the country and the cost to manage that and all of that? Or we need to relook at, we need GBC, but in a different
access requirements.
Yes, yes. So I think those will be my
licensing and regulating stations in terms of content. There's one little bit that really bothers me that I don't think we've addressed, or maybe before I came in. The stations that operate in the digital space that don't require licenses, probably don't even have to be within the geographical borders of Ghana, do not get any license from whether NCA or NMC, and yet they're operating, and depending on how sensational their content is, they're gathering very large audiences. How do we manage those ones? Because in all this discussion, I think we're missing out on that lot, the borderless ones that don't have to be physically here and be subject to all the things we are debating. Thank you.
Thank you.
I think you're next, and then we'll move to the left.
Thank you. In fact, Madam Charlotte, you've kind of taken the wind out of my sails of the first point I was going to make. It was exactly about that digital space and how we need to update our laws to cover that. In fact, about how the focus has never been on the digital, because in the estimation of the GBC that is trying to do public service broadcasting, the needs of those in the rural areas are not yet extended to the area of digital content. They don't have access to data, they don't have electricity, so really they are still relying on analog content, radio content, and so forth. I would like to encourage us, since we are trying to improve our constitution and we want to make laws that will stand the test of time, I would like to encourage us to write the laws regardless of our current problems and anticipate a Ghana in which everybody has access to data, and make sure that our laws will cover that time as well. Anticipate a time when our mothers and grandmothers in the village will be consuming digital content, and make sure that our laws regulate that. I think you were raising the issue of like the police. And the question is, should they all fall under the control of GBC created by state institutions? The most successful, financially successful YouTube channel in the world made $82 million in 2023. People find interesting. We're here in this conference room discussing matters of national import. There are millions of Ghanaians who would find this content interesting. We are streaming it live. Would we say that this commission is a state institution and therefore its live stream should fall under the regulation of the NMC? Should we be considering a future where such a live stream would be attracting millions of viewers, and therefore as a state we should be interested in what goes out there and how we regulate that content? So I'm thinking that we should be thinking of making our laws future-proof. We have current problems, but we should make our laws in a way that will protect us even after we solve our current problems. I have a question for GBC. This is just for my own curiosity. Since GBC is mandated to collect TV license fees, and we know that the compliance to that law is very poor, is there an option for the GBC to bring in private contractors to help with the collection, like GRA does? Is it an option, or will it require some change in the law? Because I don't see why we can't explore the option, bring in a private contractor, pay them a percentage, let them go out there and collect the fees, because we are all legally obligated to pay them. But we don't. So this is money we owe the state. So get some debt collectors on the job. Anyway, that was just by the way. I would like to make a recommendation around the issue of equal access, as the Constitution prescribes, equal access to airtime by all political parties. I know that in your presentation you were suggesting that the government should support GBC to fulfill that requirement. Should we not simply recommend the scrapping of that requirement, since we are seeking to review the Constitution? Should we not just get rid of it? Because I don't see the benefit of that. I don't get the time on GBC. I don't see that. I think just before I mentioned the 2 points made by my colleague before he had to leave, this issue around press freedom and the limitations to these freedoms. So I wonder, to curtail making people criminals. Why must every sanction be a criminal sanction? If a typist makes a mistake when typing a letter, misinforms generations of children, nobody puts them in jail for it. If a lawyer misadvises his client, there are sanctions. He may lose his license, but nobody sends them to jail for it. For some reason, we believe that when a journalist gets it wrong, they must go to jail. So we have a law that was written long before the Constitution, back in the 60s, that says when you, if you get it wrong, and somebody somewhere believes that what you did is likely to cause fear or panic. In fact, the way they cause public alarm or disturb public peace, then the person commits a misdemeanor. So again, we're bringing in this arbitrary use of, what's the word? The arbitrary use of, I'm losing my train of thought. The arbitrary use of discretion. So somebody somewhere can look at what you've done as a journalist and say, oh, what you did, I'm going to arrest you. The same language is repeated in the 2008 Act 75, the Communications Act. Okay, it says, if they are likely to prejudice life-saving sessions, would have to actually cause harm or loss. If your actions are likely to cause harm or loss, you can go to jail. Just because someone says it's likely, nobody to cause it, you're going to jail. So for me, I think that this idea that as for journalists, when they get it wrong, they are criminals. I don't think that is equitable at all. And if we are...
I think Musa's point in his presentation, he talked about, and it's a very critical point you raised, right? It has to do maybe in our legal tradition with the way we... But what we have not also come to accept is that limitation clauses are not absolute. Restrictions are not absolute. It may be about because they weed out that kind of penalty against a speech violation, right? And it requires a certain jurisprudence to back it and a certain shift. So it's a very important point. I think that its constitutional language can help. So the Kenyans, when you look at their limitation clause and look at the one in South Africa, they are very deliberate about how they worded those. It's where the threats to rights always come from. And in fact, I agree with Musa that our wording, the way we have formulated ours and the language we've used, is not very neat, right? But definitely, criminal sanctions attached to speech violations of the kind you're talking about likely to cause most places would not stand because they'll be considered, but we unfortunately haven't, sorted out a lot of the 1960s laws. Would not survive in most places, but we still have them. So maybe clarifying the language might help, and this is where I think maybe you could work with GJA and the other to help us with, just do a comparative search, look at how these things are regulated in other democratic jurisdictions. Look at the language in Kenya, how it works, language in South Africa, language elsewhere, and see if we could actually not do a better job of crafting the limitation clause. That is where most of the mischief is when it comes to rights. Because they are we assume that they are absolute. They too are not absolute. Limitation clauses actually must be couched in such a way that they do not do more than is needed to cure the harm they want to cure. The right must always be left intact. Just cure the little mischief that you want to cure, leave the right alone. But we haven't gone that, and so I think it's a very important point, especially the criminal sanction bit. It's a very important point.
All right, I'll wrap up with this just so that colleagues can also have the chance to contribute. These are 2 points made by my fund to help support investigative journalism, but he thinks it should be even broader and should be available to support all kinds of journalism. We say we are the 4th estate. Well, the other 3 estates are funded. So in order for us to actually be able to play our role of being a check on those applied to, when they have particular investigative projects or journalistic projects that they think are in the interest of the public, can apply to it and have a panel session made by
You should talk to the guys at IDEC, Emmanuel Akwete and others. One of their proposals is to have a fund, a public fund. They didn't say state fund, and they make a difference. A public media, but it's a public fund, and the idea of the public fund as opposed to state funding is that the sourcing can come from all manner of sources, including private sector and the like. But they have an idea there, and or even just specifically investigative journalism alone fits into that framework if it works. So maybe you should cross-check with them and see if you can align yourself to that idea. I think it's an interesting proposal.
And finally, Kojo and I agree with Prof. Karikari that if we are to set up some sort of pre-qualification for journalists, we will walk into all kinds of difficulties. But Kojo's suggestion is that, well, if we can't do a pre-qualification, you don't need to have a degree to get a driver's license. But you do need to understand the do's and don'ts of driving. Licensed to do journalism. Well, not like we can't use the word licensed, but yes, those who have passed the test to do journalism, as compared to those who have not. Some demonstration of the general principles, the ethics, maybe some sort of test that involves scenarios whether we want to make it oral so that people don't have to be lettered in order to pass it. But is there a way of considering the possibility of establishing some testing criteria? We're doing it for teachers, we're doing it for lawyers. Is it possible to do something, fashion something for journalists? That's my Kujo's suggestion. Thank you.
We have lunch coming up shortly. Mr. George Sapon, Executive Secretary, before lunch. Then we will, I think it's almost 2:30. Yeah, it's 2:35. We should have lunch. It's usually 2 o'clock, but we've gone over by 30 minutes. Let's take the comment from Mr. George Sapon, then we'll break for lunch and come back here around 3 o'clock, around 3:30.
Thank you very much, Mr. Chair. First, I am very impressed with the level of discussions and the commitment we bring. But from a regulatory point of view, the problem is much smaller than, it's like you have a stage, instead of fixing the light, some people are standing up, others are standing on chairs, others are now building scaffolds. Everything that has been said is true, but the problem is not as unimaginable as it is presented. And let me start from Sule. Sule, the point about LI 2224 in the Supreme Court judgment, when you point out that what everybody has said, that there was a provision that encouraged everybody to go look at the law. The court said so. There is no such provision in the law that broadcasters had to submit their content to the commission. It was on social media that this commentary came. I'm really encouraging everybody who is here to look at LI 2224 again. There is no such provision. The next thing that I want to point out, again, the comments that have come regarding them are important, but I still want to draw attention. The two provisions that 208 under the Criminal Offences Act and the Section 76 of the Electronic Communications Act, these are not media regulations. These are not media provisions. Section 208, you will find in the criminal offenses of almost every democracy. It flows from a major U.S. Supreme Court decision by Justice Oliver Wendell Holmes when he talks about the clear and present danger test of speech. It relates to certain situations where speech is so immediate and the danger is so imminent. So, for example, political rallies, religious environment, and somebody set up pulpit and is attacking Muslims. Those are the laws that would be used to regulate them. It is the same kind of rule that in a multi-ethnic society that there is tension if somebody sought to attack another tribe. So those rules are there. The problem with us is that because our media regulatory rules are weak, when governments come under attack, that's where they rush. These are very important provisions that sustain public order in almost every democracy. I do not have any difficulty at all if they have to be repealed, but I need to be honest about why those rules exist. With regards to Section 76 that Tanko spoke about and Kojo spoke about, these are anti-piracy laws. They have nothing to do with media. Again, it is the misapplication that is leading us there. And I really want to take my time, Mr. Chair, with your permission, to read for all of you to see what this is about. This is what the law says. A person who by means of electronic communication of life-saving service or to endanger the safety of any person, ship, aircraft, vessel, or vehicle. You understand? Anytime people read, they leave these important elements and settle on what the pirates do is to set up communication systems that misdirect the ships to the danger lines. So these provisions exist as anti-piracy provisions in almost electronic communications provisions around the world. Again, it is their misapplication here because the state lacks regulatory rules and therefore they run there. Again, I do not worry at all about whether we are calling repeal or amendment or not, but we need to understand what they are in order to be able to deal with what we want to deal with. Now, let us come back to the substantive question of broadcasting regulations and the Constitution. This is where the problem is. And it has something to do with all the questions about NMC and the NCA merger or otherwise. Around the world, there are two ways of regulating broadcasting. You may have a system where the technical parameters and the content parameters are regulated together. When you have that, we call it converged regulation. So the law will have two elements. The technical rules about frequency, transmission, and all that, and what we call the behavioral rules, which is, but it depends on the nature of the economy. All around the world, two elements will be there. The question whether you put them together or you separate them is a question of policy. So 80% of the world have non-converged regulatory systems. Just about 20 of them have converged regulatory systems. So Ofcom, FCC, ICASA are converged regulators. Most of the others are non-converged. And the way we explain it is that somebody is regulating frequency, somebody is regulating the content. So look at it like importation of vehicles. Customs may allow you to bring the vehicle in. But how you drive on the road depends on what DVLA says. But once you are on the road, your behavior is regulated by the police, not by DVLA, not by customs. So the frequency issues do not have to be mixed with the content issues. In some jurisdictions, you can do that. So in Ghana, the government made the policy to have a non-converged regulatory legislation. NCA has all the rules that we need to regulate the technical parameters in the Electronic Communications Act and its accompanying regulations. What is lacking was for us to develop the accompanying content regulatory instrument that will address the behavioral issues. So it is this simple. So what did the NMC do? First, there's a proposal to have a broadcasting bill. At the initial stages of the development, Prof. Kekari is here. I was very lucky as a young expert following them to have been part of the beginning. We considered ICASA, we were looking for an African example. And so we modeled it on ICASA and the legislation in South Africa. What we did not know at the time was that ICASA was a converged regulatory system, but Ghana was a non-converged system. So we put together a draft that is a converged piece of legislation that we are seeking to pass and enforce on a non-converged regulatory system. So each government, as they came, and they began to interact with people at ITU, they discovered that it was not the right thing to do. But because of the prestige of the authorities behind the law, nobody had the courage to say, I won't do this. So that law has been driven more by the prestige of proponents than by the force of its logic. So any government that really understands the two things sees that this I can't go forward with. But nobody is having the courage to say this. So what did the National Media Commission do? We said the broadcasting bill has two elements. the technical parameters, the content parameters. The technical parameters in the Electronic Communications Act is far superior content side of the bill and proceed to pass it. So that is what was passed as LI 2224. So every provision that the court said is unconstitutional is in the current bill of the broadcasting law that we are still dealing with. There is no provision in that law that is not in the broadcasting bill. There are only two things we put in there. One is that the offenses that are created, the owners of the networks, we call it safe harbor. They've created safe harbor for the owners of the networks. So if, for example, you use MTN's network to misdirect a ship, MTN is protected by the law. Then you, the person, speech issues. Then the journalist who makes the speech is the one who will be held liable, and the broadcasting station would be exempted. We decided that if we are going to make regulations, regulations must apply to the company instead of the journalist in order to avoid a chilling effect. Quickly, let me explain that when you make regulatory rules, you have three options: to place liability on the journalist, to place it on the company, to place it on the directors. In our work, we say that regulations that place responsibility on the journalist create a chilling effect. So in this law, we shifted no offense at all for a journalist. It's solely on the company. So for us, it was okay that Giba responded because they knew what the game was up. Quiet. That is fine for now. Plain are not as that complicated. We can let the Electronic Communications Law stand dealing with the technical parameters as is the case everywhere in the world. Then what we need is just to have the accompanying content regulatory instrument to accompany that. If we are going to do that, there are constitutional issues. The first constitutional issue is the mandate of the NMC as outlined under the Constitution. If you set up a media regulator, there are three things regulators do. The regulator is to set standards for the industry. They are to set up monitoring systems for the industry to monitor the system, and then they are to enforce the rules. If you look at the Constitution's mandate for the NMC must follow this pattern of clarity. There is no such thing in the Constitution. So when you see that the mandate of the Commission is all over the place, that's framed in regulatory terms. Then the last issue that I think is of concern that needs to be addressed in the Constitution, if we are going to keep it the way it is, would be in Article 167D. And I want to quickly read, Mr. Chair, and to point out where the problem is. In 167D, it says, the Commission is to make regulations by constitutional instruments for the registration of newspapers and other publications. And now, listen to this carefully. Except that the regulations shall not provide for exercise of any direction or control over the professional functions of a person engaged in the production of newspapers or other means of mass communication. This provision is what the Supreme Court says. Because the law has said this, the Commission cannot seek to deal with anything that has to do with the professional functions of journalists and the media. Think that the National Media Commission should be a media regulator, then we necessarily need to address these provisions. In addition to that, we need to create a mandate for the Commission that mimics the three core functions of a regulatory institution: standard setting, monitoring, and enforcement of standards. Thank you very much, Chair.
Thank you very much. Can you reduce all this big English to a submission for the because this is.
If it has to be written in a Fidasi,
I mean, for an Fidasi man, your English is not bad at all. So please give us a memo from the commission dealing with this issue, the 167D and 173 issues, and then delineating the standard setting, monitoring, and enforcement powers. Because I think that is the elephant in the room, and if we can sort it out that way, that would be extremely helpful. So if you don't mind, our lunch has been ready for some time. The secretariat staff has been hustling me out there. We can go out and have our lunch, and then we come back. We have up to like 5:30 to complete. So please, let's take a lunch break, come back and have enough energy to discuss more. Thank you.